think she agreed to every one of them.
Yeah, I saw that. It
There are
looked like
two that
it.
are at issue. Actually, they're basically.
You need to speak up and talk into the, be right behind the directional microphone.
Seems that there are two motions that are intertwined, that are still left. Dr. Timoney's testimony regarding the possible surgery, and then Laura Lambton, the life.
That's
care
the
plan.
40% possibility of similarly situated people having that sort of thing.
Yes, Your Honor.
Well, what, you know, I haven't ever practiced a case where they had like 40% probability of somebody having somebody. If I had a 40% probability because of this thing, I would, is that a jury question to see whether or not, you know, that is a medical testimony can establish that with some sort of, the words certainty and probability and possibility all don't mean all the same thing, you know? Tell me about that. Pardon?
Our case law is pretty well put together that says there are no magic words that you have to say, but possible is not enough. And I think in our reply, what we pointed to was her jury instruction, which says, what are the medical expenses that he has reasonably.
You're gonna have to speak up into the microphone. The
Sorry.
acoustic's not good here.
We pointed to the jury instruction for future medical.
Yeah.
And what it says is to provide him for medicals that you are reasonably certain that he is to incur in the future. You cannot be reasonably certain that a possibility is going to occur. By definition, it is
Well, do you
the
think
exact
that's to be
opposite.
51% of people that do that to have to be reasonably certain, or what? Let's say if the doctor testified, 51% of the people who have this procedure have this other problem later. Is that what it
Absolutely,
takes?
that's more probable than not. That's the statement. And yes, I understand.
Well,
When you look
that's
at-
more, well, it's
If we look
more
at it this
probable.
way.
If you look at the general population, that's more probable than not. But if you look at someone that has this procedure, they're more probable to have that than somebody in the general population.
I agree with Dr. Timoney, despite there's disagreement in the field, that she believes, based on what she's read, that there's a 40% increase in likelihood of a surgery within 5 years. That is not probability, that is a possibility, and that is for people who have had a surgery. So it doesn't get to probability.
Wouldn't the 40% be a probability instead of a possibility?
Say that one more time.
Well, wouldn't the 40% be a probability if you just dealt with possibilities? It's 100% possible.
Everything's
Everything
100%
happen.
possible.
Everything's 100% possible. So then you have more probable than not. I don't know. What do you have to say about it? Do you feel like his case law is as solid as he does?
I feel like the case law is solid in the case Cincinnati Insurance versus Samples. And in that case, the physician testified that 15 to 20% of his patients with injuries similar to those suffered by Samples will need future surgery. And the the Kentucky Supreme Court found that that was sufficient to support an award of future medical expenses. The case law is clear. I asked this question in all of my medical doctor testimony, is that are they at an increased likelihood of some future surgery because of the surgery that they received?
Versus the general population.
Versus the general population. And that is enough for the jury to weigh whether or not they believe that they should award Mr. Hamilton expenses for future medical
Well,
treatment.
I might be wrong on that. I could very well, but that's what I'm gonna go with, you know, and you can, I guess if we make it to a jury, you can argue that to the jury. And that's something that the fact finder will have to determine. Because I don't know, if you don't do that, I think the jural rights of the individual to cover from this injury would be limited because they can't come back and get the second bite of the apple.
Exactly.
You know, if those years, so I'm gonna allow a testimony about that. And what was the other thing that wasn't agreed to?
The other one that's not exactly intertwined is Laura Lambton's testimony regarding household services. I think, and I'm still confused because their trial brief says they have 117,000 in future medicals.
I can't hear you. I'm sorry. You have
I
to lean
apologize.
toward that microphone. Okay,
Get it
lean,
her
one
way.
right in
It's
front of you.
okay.
The one that's red there?
Yes.
Okay.
Their trial brief includes a request for 117,000 in future medicals. That is identical to the number that Ms. Lambton included for household services, basically help he would need because of limitations he has in activities of daily living over the rest of his life. My problem with her testifying regarding those damages is she has decided that the restrictions, which are not testified to by Dr. Timoney in any fashion, were caused by this accident. She has made a causal relationship to this accident, which is the sole province of a medical doctor.
I have a problem with that. I really have a problem with that. It might be that you have to open depositions back up, you know, I mean, I don't think that she's qualified to do that. Have you used her to make this causal thing before?
I have, Judge, and she's actually testified to this exact thing in 168 cases in the state of Kentucky, and it's never been appealed. She has testified in probably 5 jury trials for me, and how she makes that is she speaks to Mr. Hamilton. She is certified as a life care planner, and she projects those costs based on 2 things: Dr. Timony's medical records and testimony, and speaking to Mr. Hamilton. Now, Mr. Hughes can
Now,
cross-examine.
did you attach that portion of the deposition where she was doing that? Because I think you'd have to have a pretty strong correlation between that medical evidence, and then she could apply that as someone who is a rehabilitation expert, which I don't know about her certification here. I mean, under a Daubert sort of situation.
She's a certified nurse. I don't believe that certification is the issue, and I don't want to make that the issue. The issue is Dr. Timony, when asked about
You
future
need to get
medical
behind
expenses.
I mean, there's something, are you adverse to red or something like that?
I think so.
Okay, just calm down. We got plenty of time here. Okay, I talk and think slower than judges you're used to. Okay, go ahead.
When we took Dr. Timony's deposition, which was several years ago, I asked her whether or not she foresaw any future medical treatment.
This is the nurse you're talking about.
No, this is the doctor, Dr. Timony. If there was
I
any,
didn't know Dr. Timony was a she when you said the she. Okay.
yes, I asked her whether there was any future treatment needs for Mr. Hamilton,
Yeah.
and she said no. She did not testify to any restrictions that he had. She didn't testify to any limitations he had.
Yeah.
So there's just a lack of a basis.
Well, that's what I was saying, that I didn't see anything for is she a PhD nurse, the rehabilitation nurse? I didn't see direct correlation into what she would, from what I've seen at this point, what she says to any evidence that there was going to be a need. And that's problematic for me. You understand why that would be problematic?
Completely understand your position, Your Honor. She is actually a certified life care planner, and her CV is attached. And if we have not,
Yeah, but the problem is whether or not after she talks to him, his limitations, where you can connect that to the injury that was suffered in this case. That's the causal problem I have. And I think there's a gap there. And, you know, if you need some time to go back and redepose somebody or something, I understand that. But right now, I'm not inclined to allow her testimony.
and what we would ask is that we proffer her before she's able to testify, even in front of the jury, so that we can do, or we can do it in a deposition, however the court would prefer. She's going to come testify, obviously, to the amount of medicals that you allow her to do that.
Yeah.
But what we could do is question her for 15 minutes, even prior to, not in the presence of the jury. I've had some
That way
judges
you preserve it.
do that, right, and preserve that issue. And she is happy to testify to this court how she is able to connect the nexus and the qualifications, the certifications, the training, the scientific knowledge, and all that
I
she
don't
has.
think that she can convince me that what she sees in this patient was caused by this accident, unless the medical professional that saw this fella and treated the plaintiff establishes that. I mean, she only views what she sees. I guess she could ask him, well, you weren't like this before the wreck, were you? I mean, that's kind of like where somebody's presumptively Medicaid eligible. They come to the hospital, they'll say, well, if you don't make over $55,000, you get free insurance. You know what I'm saying?
And let me just add one more thing, Judge.
Okay.
Some of those household services are related if he has to get that second fusion surgery because of the fusion that he had as a result of this injury. There will be some rehabilitation period after
So he's one of the 40% that has to have other surgery because they had this first fusion?
Well, that's what the life care plan essentially says, and he only gets one bite at the apple.
Well, I know the life care plan says that, but is there a physician that says that he's got to have another surgery?
Well, that's what Dr. Timony's testimony was with regards adjacent level disc disease. She testifies to this. Let me back up and she testifies.
Is that the 40%?
Yes, if he develops adjacent level disc disease.
Okay, now that, I understand that, and I'm following you, but do we have a doctor that says that he has developed that, a physician that says he has developed that? Because if you do have a physician that developed that, then that physician would open up the testimony of the rehab person, as far as I'm concerned.
Well, Dr. Timoney specifically testifies to the treatment that he will need
If he develops.
if he develops
Well,
it.
who has testified that he has developed it?
Well, I've asked her, going back to adjacent level disc disease, without a doubt, you can testify that he's at an increased risk for adjacent level disc disease. Is that correct? And she says
No,
that
I'm
is
talking
correct.
about who can testify that he has developed that. I've already let you get the risk in there. But now we're talking about the rehab course of future rehab course, cost. So I'm not gonna let him, if you get there, I mean, who says that he has developed that, okay? So what you're saying is if he does develop that, then this is what the cost would be.
And the jury has to determine, based on the evidence, if they feel he is going to develop it. And if they find that he does, this is the future amount of medical bills that he would need to get the fusion, and she testifies everything that he will need if he
happens.
develops that, yeah. And he's still,
You got something to say?
The only thing I would say is the two issues, the household services and the medical, what I would call actual medical costs, I see as separate. There is testimony if you allow her to testify regarding the possibility, which we object to.
Yeah.
But if she does testify to that, then Ms. Lampton can testify to the cost that would be associated with
With
that.
medical.
I just don't think she can talk about the household services because there is no evidence that he's going to need that, or more importantly, that it's related to this accident.
Or if he had some kind of corrective surgery, that he still wouldn't need the household stuff after that.
And
Is that what you're saying?
yes, Mr. Hamilton's is a little bit of an unusual situation. After this accident, before his surgery, he had a brain surgery for a tremor, which causes some balance problems. He also has polyneuropathy, which has required the amputation of a part of his foot. He has a lot of other issues.
Yeah,
So if,
here's what I'm gonna rule. I'm gonna allow her to testify about the probability, but I'm not gonna allow any of this household stuff. Okay, I'm not gonna allow the household. I mean, they can do conjecture on what the medical care and cost would be, but not the household stuff, because there's no way, we haven't given a percentage of how many people would recover from that second surgery and what household stuff they need. So that'll be my ruling for you, John. Is there anything else?
I think that,
one question based on your ruling, Your Honor, their pretrial brief, and Ms. Lester can tell me if I'm incorrect. The only damages I think they requested were the $117,000 of household expenses. I think that probably needs to be updated if they're going to include the cost of the surgery and the physical therapy.
so Lampton's life care plan was around 300 and,
I agree. Your trial brief just didn't include those things.
What he's saying is modify the trial.
we'll modify it based on the
to-
court's ruling.
Okay.
Show it.
Okay,
That'd
we'll
be
modify it based on the court's ruling. Now, there was one last issue that I think you want to bring up about the length of the trial. Are you
Oh.
prepared to?
I think 2 days is going to be. We have to do everything perfectly to get through in 2 days. When we initially came before the
You're
court and
looking
asked
at
for
Mr.
dates,
Perfect.
I haven't been to a perfect. There's 12 people
y'all
in the
take
box,
off for
so-
lunch or what do? If y'all mediate it and work,
We
right?
mediated it. I think we can get it done in 2 days. He thinks we can't. I don't want to continue the
Well,
trial.
what we'll do is, what days are that on there?
It's Thursday, Friday, and I asked.
February 5th and 6th. If that last day wasn't a Friday and we wouldn't have to come back on Monday, I have a witness coming.
You don't work on Saturday?
I do. I'm not sure my witness will. Nor do I really want the jury to.
Well, I'm sure that is, well, if we did jury selection and some of that sort of stuff on the 4th,
Be great.
and that way out of abundance of caution, and if you had some witnesses that would be available on the 4th, we might finish on the 5th. And if we don't, that'd get the 6th. I think
The only problem I have there is when I'm gonna get my expert here. If he's gonna go on the second day, that's fine. I just kind of need to know.
I'm not gonna make you put him on the first day. You
Okay.
know, and if you tell me on the fourth that the order of witnesses would not be conducive to a good presentation, then we'll wait and do it on the fifth, okay? Seating the jury, you know, we can do that.
I have one witness.
You got one witness.
I have one witness.
Well, I don't see any reason why we couldn't come in at like noon on the fourth then. What do you think about that?
Do openings and then start full on Thursday. That'd be great.
Now, is the fourth, the Thursday or
It's a
Wednesday?
Wednesday.
Wednesday. So you're saying pick the jury, be prepared for openings on Wednesday and then rock and roll on Thursday.
And
Okay.
Friday if necessary.
I can say on Saturday too,
You know,
whatever,
won't
whatever
do
we
it.
need
We're
to
not
get this
gonna do it on
case done.
Saturday, no.
It's been on this docket for a very long time,
Just
so.
kidding.
Happy to get it done that way.
See here. Okay, we'll do it. You want to do it at noon or should we just come in? I think it would be better if we came in at noon to do that. Because that way the jury wouldn't tarry and be tired and that sort of thing and wonder why we're not proceeding.
I think that's fine.
Okay. Y'all anticipate any other pretrial things or?
Not at this time, no.
No, two questions for your court, because I want to do things the way that this court does them.
We don't try civil cases. This will be the first civil case we tried in 14 years.
I know, well, so in terms of objections, do you want us to object and state our objection from the jury? Or do you want us to
I
approach
want
the
you to
bench?
object and approach.
Okay, in terms of jury selection and picking the jury and going through questioning. Typically, how I do it is I go through a series of questions and any strikes that I have for calls, I'll approach the bench then and then,
Well, I have a tendency to do some voir dire myself.
okay,
Okay, I'll do that and then let you supplement it
okay.
as you try to influence the jury through your questions.
We would never do that.
No, I know, but there's some that do. And so, but if you have anything for calls, you can approach at that time. And if you have anything that you'd like to ask the other jurors out of the presence, you know, this courtroom is hard to do that in, but over in Monroe County, it's easier. I mean, there's more distance over there and their button works a little bit better. But if you have some lengthy sort of thing, that's the way we do it. Is there anything else?
Will you allow us to get the juror forms and the jury list prior? Because I would imagine,
They're just new and you can get them.
okay,
Now,
You can get them now.
Great.
And of course, you know, don't put them in on Twitter or anything, you know, whatever. Just you keep them, and I trust members of our to look at that. And we have a robust turnout over there. I think we had 100 maybe people. And so you can get those now. Okay, is there anything else?
I thought I could think of it, Gar. I appreciate it.
Well,
We'll see you in
I surely
February.
won't think of anything else. Okay, Merry Christmas,
Merry
Smoker.
Thank you, Judge. Merry
Thank
Christmas.
you for coming over here.
That's right.
Okay.